Welcome back to Newsline here on KTN News. Many thanks for staying with us. Now, Attorney General Paul Kihara Kariuki has withdrawn an application that he had made earlier at the High Court to suspend last week's judgment by the 5-judge High Court bench that grounded the Building Bridges initiative. We understand the AG is planning to pursue this at the Court of Appeal. This, even as Kenyans continue to hear mixed reactions following that judgment last week. Proponents of the BBI seemingly re-strategizing on the way forward. Petitioners of this who are victorious now saying they are ready for the court battle. I'm joined in studio tonight by Homa Bay Senator Moses Kajuang and also a member of the Linda Katiba, Daisy Amdani. Thank you, ladies and gentlemen, for joining me tonight to just try to keep an eye on this developing story for Kenyans, try to understand what's happening, even as the country tries to move forward. Let me begin with you, Senator Kajuang. We have had, let me begin with you, Daisy Amdani. We'll come back to you, Senator Kajuang, later on. Daisy, it has been victorious for you as Linda Katiba. You have been opposed to this from the get-go. Give us your initial reactions to that judgment last week.
Thank you, Ben, and good evening to all viewers. Ben, I think it's a victory for Kenyans. I think it's a victory for the Constitution of Kenya 2010 and a very courageous act on the part of the judges. I think it takes it's extreme courage to be able to affirm the supremacy of the Constitution and the sovereignty of the people of Kenya, particularly when you are faced with an administration that is vindictive and generally does not respect the basic principles of constitutionalism. But aside from that, and when we talk about, that the proponents are, of course, they're shattered by that ruling. As anybody who was pursuing something would be. But I think it's instructive to look at the reaction of Kenyans. Kenyans are elated. Many Kenyans feel that the judiciary has spoken on behalf of the people and have saved the people from what seemed to be an inevitable push to distort our constitutional order. And for me, I think it goes beyond just being a landmark ruling. I actually consider it a prophetic action. I always remind people that, judges sit in a very special position. Judges sit in a place that is set aside for Yahweh, the supreme judge of all. And judges are the people who can take away certain rights from you. I mean, a judge can take away your right to freedom. They can condemn you to death. But judges also affirm certain basic principles. And so by that ruling, in my opinion, I actually believe that it was prophetic. Prophetic in the sense that these judges have spoken on behalf of the people and they have made a declaration to affirm that Kenya has indeed changed, that on the 27th of August 2010, Kenya changed. Kenya changed from a country where the president and parliament were supreme and restored the essence of a republic where the people are the sovereign. And anybody who exercises the donated power of the people must do so within the confines of the Constitution as laid out. And the president has not been faithful to those principles. We have seen the president entrench a culture of unconstitutionalism and total disregard of the rule of law. And the judges, on behalf of the people of Kenya, have given pushback. So I think it is momentous. I think it's actually a more momentous moment than the nullification of the presidential election. Because by this, the judgment has indicted the leadership of this country from the executive to parliament. It's a huge indictment even on parliament, who are supposed to be the representatives of the people, that sovereign, who they are supposed to defend and on their behalf check the executive. But they have been a marionette on behalf of the executive, simply doing the bidding of the executive and not the bidding of the people. So it's a gross indictment. And if indeed Kenya was a functioning democracy, the Attorney General should have resigned, and the president should have very serious consideration, because the declarations made by that judgment are such that they are impeachable. So I think that it's serious, and it's something sobering. And for me, it's an exciting time for Kenya, because it has re-energized those of us who actually believe in the power of the Constitution 2010 to transform our nation and to fetter the excesses of power within the bounds of the law.
We'll get into what that means for the president. Senator Kajuang, the proponents of the BBI have especially been caught flat-footed, basing this on the reactions we have been hearing. Some of them have been disputing the judgments. Others have been disparaging the 5 judges of the High Court. What are your initial reactions to that ruling on Thursday last week?
Thank you, Ben, and good evening to our viewers and to my sister Daisy, who is celebrating. And I don't think that there is a God who favors half of Kenyans and disfavors the other half of Kenyans. I think God is for all of us. And those who think that that ruling, because it favors certain political players, that it is God's hand, I think they are committing blasphemy. I have taken time to read the landmark ruling and the declarations by the High Court. And I think that anyone who has read what the High Court judges said must pause and reflect on a few issues. We in ODM and we in the opposition and NASA fraternity have always demonstrated our respects for the judiciary. You recall that it was a judiciary that overturned what we consider to be a fraudulent presidential election in 2017. And our opponents were not happy, but we celebrated at that time. But we were conscious that even though we celebrated, half of Kenyans felt that their will had not been reflected in that decision of the Supreme Court. We in the Senate, because I am a senator, and I must tell Kenyans that the Senate today exists because of a strong judiciary. Initially, in the formative days of devolution, we saw a situation where the National Assembly felt that they had the monopoly on all bills, including the division of revenue. And it took the Senate and senators to march to the Supreme Court to seek an opinion of the Supreme Court on the role of the Senate on legislation and specifically the division of revenue. The Supreme Court at that point affirmed the centrality of the Senate in lawmaking and particularly on matters affecting counties. We cannot therefore celebrate all these victories and then start scandalizing the judiciary on their interpretation on the matters surrounding constitutional amendment. Ben, Articles 255 to 257 have not been tested since we implemented this constitution. Perhaps during the Okoa Kenya days, we could have tested it. Maybe during the Punguza Mzigo days, we could have implemented it. This is not a time for partisanship. This is a time for us to reflect on the jurisprudence around constitutional amendments. And I'm going to say something which might sound a little bit off the beaten track, because I don't speak, tonight I probably will not be speaking for ODM or NASA. I will be providing my personal views as a senator and a citizen of the Republic of Kenya. I think the 5 judges of the High Court have enriched our jurisprudence around constitutional amendment. The question and the worry is, and this was my contribution on the floor of the House, if you look at Article 257 and you do not have a deep philosophy around it, if the process of amending the Constitution can be as easy as we have seen with the BBI process, then one day we shall be amending the Constitution to do away with term limits. And one day we shall be amending the Constitution to do away with the Senate or any other institution that seems to be an irritant to the executive. If a tyrant was in power in Kenya and we made it very easy to amend the Constitution, we will go the Uganda route and abolish term limits. We'll go the Rwanda route and abolish term limits. So I believe that the High Court decision, which is subject to appeal, and I'm conscious that the Attorney General and other players have moved to the Court of Appeal, and this matter is not closed until it goes all the way to the Supreme Court. But I think it offers a very good and a very sobering point of reflection, irrespective of which side of politics you are on. This, alongside the Justice and Legal Affairs Committee report, enriches our jurisprudence and gives us something substantive that will complement what the drafters of the Constitution put in and will safeguard our Constitution from arbitrary amendments. Personally, I do not think this is a time for partisan politicians to celebrate. This is a time for Kenyans to reflect.
I have to ask you this, Senator, very quickly. You sound like you agree with the ruling on the basic structure doctrine that was part of that very detailed ruling. Is that correct?
Ben, there are elements of the ruling that I have a problem with as a private citizen and as a leader in this republic. I have certain problems with the issues touching on the IBC and the issues of quorum, whether we go with the Constitution or we go with statute. I have problems with that determination because it might invalidate the elections and all the actions of the IBC since the other commissioners left office. I have certain problems with the determinations on the role of the president in these matters. But on the issue of the basic, the doctrine of the basic structure of the Constitution, I think it provides food for thought. There are those of us who believe that, yes, the basic structure doctrine could apply to Kenya. But if you go to Article 257, 255 to 257, there are areas and there are sections and chapters of the Constitution that have been ring-fenced, that Parliament or county assemblies or any other body cannot amend them unless you go back to the people. One would argue that that is an affirmation of the basic structure concept. Perhaps what the judiciary espoused was that the process of amending the basic structure, the basic architecture of our Constitution should be more detailed than what is provided for in Article 257. They talked of civic education, they talked of public participation, they talked of a constituent assembly, and they talked of a referendum. One could argue that the BBI process went through those stages. There was civic education, there was public participation, and the 1 million signature threshold, which was exceeded by 3 million, could be the equivalent of a constituent assembly. On principle, I think that the basic structure concept is applicable, and from a process perspective, I think that the actions of the promoters of the draft bill have fulfilled some of the issues that were highlighted by the High Court.
All right. Daisy, the High Court, the 5 judges ruled that the basic structure doctrine, which limits power of the legislature to amend the Constitution, is applicable here in Kenya. That was one of the main takeaways of that petition by David Ndii and others. What are your thoughts on that?
You know, Senator Kajuang was doing very well, and I was agreeing with him on certain points up until the time he talked about the BBI following through on the process. Now, the judges affirmed the doctrine of basic structure, and it is true. When you look at the protected clauses, it actually alludes to that basic structure, basically, that those specific 10 protected clauses, if amended, must be amended by the will of the sovereign, the people. And what I like is that before giving their declarations concerning the questions posed to them, the judges took time to walk Kenyans through the process by which we came to the kind of constitution that we have today. And part of that basic structure doctrine is that the people are central. Now, what the BBI has done is that it has created a mongrel of a process that is not familiar in the Constitution. It is unknown to the Constitution that we have. You either have a parliamentary process or a popular initiative. You cannot create for yourself a mixture of the two and say that you have then followed the process. Now, they talked about the people, the Constituent Assembly. They gave us the history of how the Bomas process came about. If you recall that before we had the Bomas Constituent Assembly, we actually had the people's process. And I think that was one of the rich things about that ruling, was that it took us back to understand those unsung heroes of Kenya's history who had the foresight to understand that for the Kenya of today, unlike the old constitution that was brought about by a few people sitting together and experts coming together and deciding for the people that this is the kind of constitution that is needed, that the people were involved. The necessary law was put into place to begin the process of amending the constitution and taking the views of people on board. Now, you can't talk about the BBI having followed that process, because remember that there were district focus groups that were constituted to give their views. We had the Bomas Constituent Assembly. We had the commissioners who went around the country and came together, and there was a very rich discussion. And it didn't take place over 1, 2, 3 years process. It was a lengthy process. Now, you cannot seek to undo that process through a process like the BBI that started off as a handshake. And I think it's important for us to state that the handshake was indeed important, and many of us celebrated it because it brought a sense of normalcy. However, you cannot use that process to then hijack the will of the people and come with a process that now you are telling the people this is the way it is. The collection of the signatures, they talk about 4 million signatures. How were those signatures collected? Were the people consulted? Remember, Linda Katiba, we were observers to the signature verification exercise. Not a single of those booklets that had the signatures had the bill attached to it. So what were people signing up to? The provincial administration was used to collect those signatures. The Constitution says that the promoters of a popular initiative must use their own resources in promoting and collecting those signatures. Now, the state cannot abuse their power and the state resources to then circumvent the processes that are allowed to them. What the ruling has said is the separation of powers, the sovereignty of those people, of us, we the people, the sanctity of devolution, and all those 10 clauses that are contained within the Constitution that can only be amended through a referendum can only be done when you follow the 257 principles, popular or, what do you call it, the parliamentary initiative. Now, the president cannot decide. Hello?
Yes, go ahead, Daisy.
There's a bit of a... Can you hear me well?
Yes, we can hear you, Daisy. We can hear you. Go ahead.
Okay. Now, one of the things that the judges brought out was that the president cannot turn himself into a private citizen for the purposes of initiating a popular initiative. Okay? That is gross abuse of power. While indeed he is a citizen of Kenya, he is the president. He is the holder of the office of the presidency. And that presidency comes with certain powers and privileges that are not available to ordinary citizens. But he does have an avenue through which he can amend. And I agree with what Senator Kajuang says, that in affirming the basic structure doctrine, the judges were not saying that the Constitution cannot be amended, but it must be amended in taking into consideration the principles by which that basic structure was adopted. Now, the president, who is the custodian, really, of the Constitution, because he swears to uphold and defend the Constitution, cannot, using the powers of the office of the presidency, the resources available to him as the holder of the office of the presidency, abuse his powers to then decide that he's a private citizen and that he is now going to conduct a popular initiative using public resources available to him, command public resources available to him through the powers of the office that he holds. And when he is stopped in his tracks, he says that, no, I am also a private citizen. The president, as the powers conferred to that office, has the Attorney General, through whom he should have formulated a bill, brought to Parliament, had the discussion, set up the commission properly, and then take the people through the process. So we're not saying the Constitution can't be amended. We're saying process is important. And that is what we have been standing on. And I think that is also what the judges have affirmed. They've also talked about the omnibus. The BBI is seeking to amend clauses in at least 14 chapters of our Constitution, which has 18 chapters, okay? That is not amendments. That's an overhaul, okay? You cannot seek to bring to the people an omnibus of amendments without their understanding of how each and every amendment will affect the other. So when you think about basic structure, think of it like a house. And maybe because Kenya, we've become so lawless even, in the way we do our construction. But you think about a house that has been built and it has certain architectural features. When I was growing up, I remember that you couldn't even make any improvements to your house until you got approvals from the city architect, who had to come and ensure that the structure of the house could actually take those improvements without destroying the entire architecture of the house. And that's the same basic principle, that there are certain clauses in the Constitution, if amended without thought of how it affects the overall architecture of our Constitution, can end up crumbling the entire constitutional framework of our country.
Let's bring in Senator Kajuang into this. I want to hear his thoughts on the same. Senator, this thought or this idea that this process is not really people-driven, what are your thoughts on it? And do you disagree with the 5 judges when they say that the processes were not followed, the 4 stages, civic education, public participation, constituent assembly, and referendum? Do you think this process has been people-driven, coming from that issue of President Uhuru Kenyatta and Raila Odinga being the genesis, really, of this process?
Ben, I have been part of this process. There are those in the political space who chose to stay away because they did not want to legitimize the exercise for political reasons. When the BBI task force was going round, I presented myself before them, and I do recall you were in Homa Bay town at a hotel called Cold Spring Hotel. I made a very detailed presentation to them. Even before the BBI task force came to Homa Bay, I held a youth conference at the same hotel where I had several hundred youth, and I was supported by civil society. We brought the young people from Homa Bay together and asked them that what are your views of the 9-point agenda? On that basis, we generated a memorandum. When the task force came to Homa Bay, I presented that memorandum on behalf of the young people and the entire populace of Homa Bay that I represent, and have been part of this exercise subsequently. And I can tell you that from where I come from in Homa Bay County, if there was a benchmark for civic education, if there was a benchmark for public participation, because we as members of parliament, we have gone out of our way. In fact, I have been busy distributing BBI booklets. I just stopped because of the COVID pandemic. We have met that threshold. We have met the threshold that the High Court said must be attained if you are going to amend the architecture and the core of our Constitution. Was it achieved in all corners of the country? Perhaps I might not be able to respond to that, because we know that in some corners of the country, because of political rhetoric, there was hostility to the process. Ben, remember that the High Court judges, when they assessed the role of the president in this process, they only had reservations because the president, at the end of consideration by the county assembly and by parliament, he is the one to determine which matters go to a referendum. And so the judges said the president cannot be a player and a referee. Now, I think that there's something in there. We have argued that Uhuru Muigai Kenyatta is a citizen of the Republic of Kenya. Uhuru Muigai Kenyatta is the main policy driver in this republic. Uhuru Muigai Kenyatta, if he decided to have a conversation with the opposition, to come up with constitutional and statutory and policy changes that can strengthen the Kenyan nation and that can ensure the supremacy, sovereignty that is talked about in the Constitution, there is nothing fundamentally wrong with that. It only becomes wrong if at the end of the process he is assenting, if at the end of the process he is the one directing people to go into a referendum. And I think that was the main thrust of
Senator Kajuang, what the petitioners and the judges were saying is that the process was not followed in terms of this being a popular initiative, that it was flawed from the word go?
But Ben, remember, the High Court is coming in retrospect. When you talk, and there was another determination that we do not have a sufficient, adequate legal framework to guide the exercise, despite the fact that the Elections Act has certain provisions to do with the referendum, despite the fact that Article 255 to 257 talks about amending the Constitution. But they said we did not have a proper legal framework. Now, to say that the process was not followed, I think that is speaking from both ends of the mouth, because you're saying that there was no framework, and then you're saying the process was not followed. But even if you work backwards on the process that was enunciated by the learned judges, they talked of civic education, they talked of public participation, they talked of constituent assembly, and they talked of a referendum as a basic prerequisite to alteration of the basic structure of the Constitution of Kenya. I believe that the team that was promoting this particular matter can demonstrate that they met that threshold. But then the more fundamental thing, Ben, is that should we make, and my earlier comments was that the amendment of the Constitution should not be so easy that a tyrant can abolish term limits, can abolish parliament, can abolish Senate, and can come up with some very retrogressive constitutional amendments that touch on the core of the Constitution. But then there must be a balance. Otieno, who is a fisherman in Remba Island on Lake Victoria, what if he desired to exercise his civic duty and to use Article 257 and to initiate a popular initiative to amend the Constitution? If we place the threshold so high, and we are saying that you must have conducted public participation and civic education and distribution of the bill in English and Swahili and in Braille across the country, nobody will have the resource, no one will have the capacity to execute Article 257 beside the state and non-governmental organizations. So there has to be a balance. And that's why I'm saying I'm excited that the High Court has highlighted these issues. And as we proceed to the Court of Appeal and as we proceed to the Supreme Court, I hope that we're going to strike a perfect balance that will allow Otieno, Wanjala, Wanjiku, sitting wherever they are, to invoke Article 257, but will also deny a tyrant who's bent on altering the architecture of the Constitution and foundation of this country from achieving it in an easy fashion.
All right. Before we talk about the Court of Appeal process, the appeal process the proponents are thinking about, Daisy, what are your reactions to that?
Well, let me say this, and I think that Senator Kajuang needs to separate issues, okay? There's one thing about Otieno and Wanjiku proposing a popular initiative, and it has been done before. We've seen it with Okoa Kenya, we have seen it with Punguza Mzigo, and there are several others. There's One Kenya Alliance. Even us as women, we started our own, the Green Amendment campaign, okay, and collecting signatures and all that, okay? The threshold that has been set for public participation of 1 million signatures, while it is a high threshold for an individual citizen like Otieno and Wanjiku, it is a very low threshold for a government. And we saw it. We saw it with the way the government used the provincial administration to bulldoze their way. Using state resources, in a matter of time, they had collected 4 million signatures, okay? That is number one. Number two, you take it to the IBC. So assuming it's a genuine popular initiative and not the BBI, which is not a popular initiative. It's being called, you know, we cannot keep calling something in the hope that it will become that thing. So I want us to establish that BBI is not a popular initiative. So, but assuming that we do have a popular initiative, as a citizen or a group of citizens, if you come up with a popular initiative, remember, it goes to IBC, where IBC verifies those signatures that they are indeed from registered voters, and then they send it from, at that point, government resources do kick in because the IBC then sends it to the counties for debate and confirmation. So if you get half of the counties, at least 24 counties, endorsing the bill, it comes back. Now, if any of those proposals touch on the articles, the protected articles, then they must be subjected to a referendum. And at that point, the IBC does have a responsibility to ensure that the people get copies of this bill because it has already passed through the process of the 1 million signatures. The counties, half of the counties have passed it. So then they then are supposed to then conduct, publish the bill, conduct the civic education, ensure civic education is conducted ahead of a referendum, okay? Because a plebiscite is akin to an election. However, the BBI, number one, it consolidates several matters, okay? You're talking about a multiplicity of amendments, proposed amendments, not just to articles that fall within the protected clauses, but several other articles that completely seek to alter the framework of our Constitution. That was the import of the BBI. It is about altering the constitutional order. And while Senator Kajuang believes that the president, who is supposed to be, the one defending and protecting and promoting the Constitution, let us remember, he has been in the forefront of disobeying that same Constitution. In fact, the question we should be asking is, why the urgency to alter fundamentally a constitutional framework which he has so disregarded and not even fully implemented. Let's not forget that the Constitution is not fully implemented. And even the part of the 9-point agenda talking about inclusivity, among the principles that the president and the current parliament have failed to implement are the principles on inclusivity, talking about the 2/3 gender principle, talking about the enfranchisement of persons with disability, talking about Article 100 that is supposed to ensure that the women, youth, and persons with disability and other marginalized groups are represented. None of these have been implemented. And there are several other things that the Constitution, that this Parliament and the Constitution...
You're going to have to just hold that thought for a quick second. We're coming back to talk about that and, of course, the petition that is in court today. Just hold that thought for a couple of minutes. I want to go to Juja in the county of Kiambu in that parliamentary by-election where we understand there's there's an incident happening there. There has been some kind of chaos. Emmanuel Toh is there for us. Emmanuel, I don't know if we have Emmanuel. All right, we are trying to get hold of Emmanuel Toh in Juja. That is, of course, at the Mangu High School where there is a constituency tallying center. We understand that there has been some kind of altercation. Let's listen to what's happening. Emmanuel, we have Emmanuel Toh live on the phone. Emmanuel, what is happening there? We understand that tallying has been suspended for a few minutes. What's happening there?
Well, Ben, as you can see right now from the pictures that are live from our team here, some of the agents, actually all agents representing all parties that are involved in this by-election, have been set out by police officers after one of the agents that was actually came from the team or the side that was with the governor of this county, James Nyoro, came up front and banged some of the tables here that were from where the IBC officials were sitting, and that is what occasioned all this. And he was saying that the count should be stopped, and just to make sure that the results that were coming in should be verified fast before they were put on the screen that we can see right here in this poll. And as we speak right now, the leader in this, according to the leaderboard, actually according to the results that are here right now, from 16 polling stations, 858 votes are from George Kembore. Kajuang has 439, and that is one of those things that have caused this chaos. And police officers are just trying to make sure that anybody who is not a member of the court is safe, or and the police officers are just rushing up there just to make sure that they get to know who those people are there. And there are so many other observers who are just sitting up, observing all this from this point. And maybe we will be getting to know exactly what the police officers wish about this, because everything has stopped here. All the chairs have been, some are even throwing the seats on each other. And it's really chaotic right now. It's really chaotic. And that is Ali, police county commissioner, just sitting and saying that everybody should.
Emmanuel, did we, before this chaos, did we have a picture of how the tallying was going before it was suspended?
Of course, everything was going on well. The IBC officials were just reading out the results as they came in, and out of the 184 polling stations, 15 of them had come in, and George Koimburi of the People's Empowerment Party was already leading, and as we can speak right now, he has 858 votes, and Wetito Susan Geri has 439, and that is something, because someone just came from the crowd and said that everything should stop, and that is why we have to be pushed out. And police officers and Ali Nuno is just giving more instructions on what to do going forward.
All right, let's see if we can hear what the security officer there is saying. Let's listen.
All right.
Pictures from the tallying center, constituency tallying center in Juja, in that Juja parliamentary by-election, where Emmanuel Toy is trying to piece together what's happening there. We understand the Independent Electoral and Boundaries Commission, IBC, has suspended the tallying process for now because of that violence. We understand that prior to the suspension of the tallying, the Jubilee candidate, Susan Njeri Waititu, was trailing the PEP candidate, that is George Koimburi, and then obviously right now the tallying has been momentarily suspended. We do not have an idea of when that is going to resume, but we are keeping an eye on what's happening there. There is a lot of security boots on the ground, so things should be coming back to normal anytime. From now, we will be going back there to just see what's happening. We have seen the governor of the county of Kiambu. They are also looking quite animated. It is a very tightly contested race from what we're seeing from the numbers streaming into the constituency tallying center. It is a neck-and-neck affair between the PEP candidate, that is George Koimburi, and the Jubilee Party candidate, Susan Njeri Waititu, the widow of the immediate former member of parliament, the late Munyo Waititu. So the tallying has been suspended. Emmanuel Toy is there for us. We shall be going back there immediately. We need to know more. Those are live pictures from Juja at the constituency tallying center. All right, I shall be going back to Emmanuel Toy shortly, but let's come back to this conversation. I still have with me in studio here on Newsline, Senator for Homa Bay, Moses Kajuang, and Daisy Mdani, a member of the Linda Katiba group. Ladies and gentlemen, let's wind up this conversation. Here at KTN News, the news comes first. Hope you understand that. Now, today, the proponents of the BBI, Senator Kajuang, want to go to the Court of Appeal. That is at least what we've heard from several people who've spoken about it. The Attorney General did file a motion, did try to stay order of that ruling last week. Today, he withdrew that application. We understand that he wants to go to the Court of Appeal. Why file that stay order in the first place? And what do you think is the strategy here, if you can indulge us?
And let me not get into the strategy, because this being a live matter, it might be, strategy is evolves very quickly. But what many of us think is that we need to have a candid conversation. We should not use technicalities of the judicial system to allow us to proceed. We need to ventilate and ensure that we have a unified philosophical view that can enable us to proceed with this very important exercise to avoid a situation where we are using technicalities rather than ensuring that the will of the people is on board whatever activities we are doing. And Ben, I know Daisy had told me to separate issues, and I want to ask also to separate issues. The issues of disobedience of court orders by the executive, that is a legendary matter. But on this particular matter of the BBI, and there are people who have been talking about things like a reference to the president as Mr. Uhuru Muigai Kenyatta. Personally, I never have any problem if someone does not refer to me by my title because it's not on my birth certificate. And I think that should be the least of our worries. The High Court judges, when calling the president to order, only mentioned the fact that the president cannot be a promoter of a popular initiative when at the end of the process, he is a referee who decides whether the matter goes to a referendum. That was the president's culpability in the eyes of the High Court judges. I don't think that there was more to it than that. There are people who are saying that the High Court judges, of course, well, not people are saying, but there's an issue of violation of Chapter 6 of the Constitution. I think that's a serious issue that needs to be dealt with at the Court of Appeal, whether the president, acting on good intentions to unite the country, acting on good intentions to ensure that Kenyans are not killing each other because of elections and because of political positions, can then be said to be in violation of Chapter 6. The president has done a good job, but the High Court is saying that he has done it untidily. And there is an analyst who looked at this ruling, a legal scholar from India, and said, if you're going to insist that the president cannot initiate constitutional amendments under Article 257, then fine, what he will do is that he will not sign on anything, but he will use a proxy, and he will still achieve the same end. That is a conversation we want to have at the Court of Appeal and in the Supreme Court so that our jurisprudence is enriched. Now, Ben, there's also something that I wanted to react on. How possible is it for Otieno, Onyango, Wanjiku, and Atuoli sitting wherever they are to invoke Article 257 to amend the Constitution in light of the basic structure concept? The basic structure concept and the Linda Katiba, one of the orders or determinations that they wanted the High Court to make was with regard to eternity clauses. And they were arguing that there are certain clauses in the Constitution that is unamendable. And the High Court said that basically everything is amendable, including that basic structure. But there has to be a threshold, there has to be a minimum civic education, public participation, constituent assembly, and a referendum. We can't demonstrate, I want to repeat, that the promoters of the BBI can demonstrate that that threshold was met. Perhaps meetings were called which were not described as constituent assemblies, but there were meetings at Bomas. And by the way, when you talk of constituent assemblies, I was one of the researchers at the CKRC sessions in Bomas. And I believe that that kind of session where you're bringing delegates from all over the country is extremely important, but it is more fundamental when you are overhauling the Constitution rather than when you are amending the Constitution. I think that the High Court has brought in certain aspects, borrowing from international law and international practice. What we need to do is to domesticate it so that it then does not become another impediment to citizens exercising their civic duty and the constitutional right to petition and to ensure that they can make proposals to amend the Constitution. Finally, the issue of omnibus referendum versus multiple choice referendum. One would argue that the law currently allows the IBC, once it has received the bill, after having been processed by Parliament, to frame the question and take it to Parliament for parliamentary approval on whether it is one or multiple questions. What is the High Court saying? The High Court says that it is a must that if you have more than one amendment, that you have a multiple choice referendum. They are taking away the role and duty of Parliament in this particular matter. because the law as it is right now, and that is one area where there's no ambiguity, says that once the president asks the IBC to conduct a referendum, the first thing the IBC will do will be to frame the question and consult the leadership of the National Assembly to get assent of the National Assembly on the question or questions to be asked. Why do we want them to take away that duty, that role that has been assigned to Parliament? And why do we want to subject Kenyans to a referendum that will be far worse than the Kenya Certificate of Secondary Education? It will be an examination. If we are complaining about you can imagine a situation where Kenyans are faced with 17 questions in a multiple choice referendum. That is impractical. And those are things that need to be domesticated. If that is the precedent in other international...
Allow me to take you back just a minute, just in 1 minute only, before I go to Daisy, for what Kenya should expect in court, if that is the way to go. The political class has been accused of bastardizing Chapter 6 of the Kenyan Constitution. Do you believe that the ruling by the 5 judges of the High Court were right with that indictment on the president? Do you think the president has opened himself up for any kind of litigation moving forward?
I think the political class is guilty of far weighty violation of Chapter 6. The political class is guilty of corruption. The political class is guilty of acts of omission and commission that have stagnated our economy. The political class is guilty of far weightier acts of culpability than a president who has decided to put his nation forward. A president who decides to shake hands with his most fierce political adversary. A president who decides that what his legacy will be to unite the nation and to live together a country that is united. You cannot then cite the president for violation of Chapter 6 simply because he had good intentions, but the manner in which he executed them fell short of the expectations of the High Court. I think if the president was to be indicted on corruption, if the president was to be indicted on the economic malaise that this country faces, those would be much more substantial accusations on his part of violation of Chapter 6, but not a president with the intentions of leaving a united Kenya. And I think everyone agrees, even Daisy says, that the handshake was a wonderful thing. The intentions were great. Perhaps the execution was not elegant.
Daisy, give me your quick reaction to that, and also tell me this. Are you ready for a court battle if it goes to the Court of Appeal?
Thank you, Ben. And let me say this. I think it's important to state that the BBI is not an amendment to the Constitution. It's an overhaul of the Constitution. You cannot call amendments to over 14 chapters of the Constitution that has 18 chapters an amendment. That is an overhaul. So let's establish that. It is an attempt at overhauling. So you can't overhaul the entire constitutional order without following due process. That is one. Secondly, Senator Kajuang talks about the president wants to leave a legacy of a Kenya that is united, electoral processes that, do not cause conflict and all that. The legacy that the president can leave us is a legacy of constitutionalism and the rule of law, because that is what will underpin the safety and security of Kenyans. If the president and the political class follow the rule of law, then we will not have the kind of conflict that arises within the political contest. Kenya's electoral problems are not because of the Constitution. Kenya's electoral problems are because of interference in elections, and we are witnessing interference taking place before our very eyes this evening. And we've seen it in the previous by-elections, and it should be something that should worry us all, that we have such excessive interference in our processes, and the political parties are always engaging in violent manners. And they don't want to be bound by the rule of law. So this is the problem. It's because people feel that elections do not ultimately express the true will of the people, because at some point they are interfered with. Now, the BBI does not address itself to that thing. None of the amendments proposed under the BBI actually seek to address the issue of the electoral process, of electoral malfeasance, and how we ensure that political parties and political players are held to account when they break the law. BBI doesn't address itself to it. Instead, what it does, it creates positions for ethnic barons, you know, saying that if we have this many people at the top of it, then we are going to have peace. So in essence, what they're telling us is, for as long as we are not going to be in power, we're going to cause trouble. And in fact, let me say this, Ben, because this is something that we need to be careful about. When you look at the reactions of some of the people who support the BBI process, it makes you worried. One of them talked about the military being the custodian of the Constitution. So for me, I consider that a direct threat. When we have the Secretary General of the governing party saying that judges need to understand the value of interdependence, and that when they make their judgments, they need the police to escort them, and that the people who are celebrating the court ruling are dancing on the graves of the people who lost their lives and property in 2007, 2008, that for me sounds like an indirect threat, where we are being told that if we don't get BBI, then there are people who will cause problems. Because, you know, conflict and violence doesn't arise on its own. It is engineered by people. And in Kenya, it has been engineered by people who are determined to hold on to power, regardless of what the will of the people is. Now, for me, that is the conversation that we should have. And I think that when we look at throughout the BBI process, we've been having by-elections, and they have actually been extremely conflict-prone, with a very heavy hand on the state. So what does that mean? 15 months to a general election, you know? What does that actually mean for Kenya? Are we being told that if they don't have their way with regards to the BBI, which, by the way, is not popular with the people? It is not popular with the people because right now, when you look at the people, nobody is making any lamentations other than the supporters of it. And I mean, even the Senator Kajuang, and the leaders who are supporting it, who are upset by the ruling, also need to defend their position. The position which has shown that Kenya is a country that is prone to professional dishonesty, because we have lawyers, we have leaders who are really looking for avenues through which they can, you know, square a circle. You know, this is really what the BBI is about. It's about trying to square a circle. And I think that we need to be careful in the days ahead and to watch very carefully how the government moves with this. The judges, I've seen on social media, there is a smear campaign being run on the judges, and that also is worrisome when we have people who support the administration, or maybe even people who are supported by the administration, to run smear campaigns on an arm of government that is simply doing its duty and safeguarding the Constitution and affirming its supremacy and the sovereign will of the people. So going forward, I don't think that we should be casual about it. We should be concerned about how the leadership is behaving around this ruling, and pray for the safety of our judges, because we saw what happened when the presidential election
I need to get your closing remarks on this very quickly because of time. Senator Kajuang, in just 1 minute only, what do you tell those people who have been supporting the BBI process? And what would you advise? I know you said you wouldn't speak for ODM or NASA, but would you rather go to a parliamentary process rather than appealing this? Your closing, please.
Ben, the people that I represent, the people of Homa Bay, are fully in support of this process. I don't know where Daisy did her opinion poll. Maybe she used Irungu Kangata's services, but BBI is popular, and that is why it was passed by county assemblies. passed by the National Parliament, and the people have got expectations. What the High Court has told us to look at is the process. The High Court did not even delve into those other issues that Daisy is raising, whether it is priority, whether this is the time, or whether BBI addresses electoral injustice. It just said, get the process right, and remember that the basic structure doctrine applies in Kenya. And Ben, I enjoyed that conversation, and I think that is going to enrich our jurisprudence. Even if you're going to go for a parliamentary initiative, it is important that we get some of those questions answered, so that for the benefit of Otieno Onyango, who tomorrow will want to invoke Article 257, they are appropriately guided. Of course, there is concern around timelines and the next general election that is almost due. But I think that it is important that we answer all the pertinent questions at this point. And I do believe that we have put in place, we have assembled an effective legal team. And in the coming days, we shall be discussing issues. We shall not be discussing politics. We shall not be politicizing this matter as has been done in the public domain. This is a time for us to enrich our jurisprudence, and this is a time for us to ensure that we make our constitution one that can be safeguarded by a tyrant and one that can also allow to pursue his aspirations. And finally, if President Uhuru Kenyatta was seeking to amend the constitution to extend his term, then he would be selfish, he will be guilty, he would be guilty of violation of Chapter 6, and we would even be calling for his impeachment. Is he calling for an extension of his term? Is he calling for any benefits that accrue to him as a person? None of the above. What he's trying to do is to leave behind a united Kenya. And I support that. Of course, we need to correct the process as advised by the High Court, but let's wait for the Court of Appeal and the Supreme Court.
Thank you, Senator. Daisy, very quickly, 1 minute only. Are there things in this process that are good for Kenyans that do not require a referendum, or should we necessarily throw out the baby with the bathwater?
Well, in my opinion, the ruling has thrown the baby out with the bathwater, and I hope that it will be upheld. I'm not saying the Constitution can't be amended or that there are clauses that, cannot be looked at. It is not, no Constitution is perfect, and it is a discussion that can be had. But right now, it is not the discussion to be had. In fact, if anything, I think that aside from putting the BBI aside, this is an opportunity for our leaders not to be concerned about amending the Constitution, but looking at the problems that are bedeviling Kenyans. Kenyans are facing a multiplicity of problems, and that's really what our leadership should be concerned about. And this continued focus on the BBI and, appeals and trying to, intimidate judiciary, for me also tells me one thing, that the current leadership in this country is obsolete. It is not capable of finding solutions to the problems bedeviling Kenyans. And so they would rather have us running around in empty circles debating amendments to the Constitution and what have you, instead of focusing themselves on the economic crisis and the livelihood crisis that Kenya is facing, the health crisis. And that's what we should be focusing on. So for me, I hope and I pray that the Court of Appeal will uphold the judgment of the High Court. It was a sound judgment. It was a beautiful judgment. And I agree with Senator Kajuang on this. It has enriched the jurisprudence of Kenya, and I think that we need to reflect more on that. Moving forward, Linda Katiba, we are actually going to disseminate that judgment to Kenyans and help them to understand it in depth, because what that judgment did was hand power back to the people. On the 27th of August 2010, a baby was born. They have tried to kill this baby. They have undernourished it, but the court has handed the baby back to the people. And we must ensure that the people understand that they must feed the baby of Constitution 2010, constitutionalism and the rule of law, for that transformation that our Constitution envisions for our country.
Thank you. Many thanks to you both for your time tonight. We do appreciate your thoughts and your presence here on Newsline. Daisy Mdani, a member of the Linda Katiba group that has been opposed to the BBI process from the get-go, and the senator for the county of Homa Bay.